Good morning. This is Richard DeBost, Cody DeBost and Cross. I'm joined by John Treblecock and Wendy Murray of Precedent Management. I want to thank Wendy for helping us host this legal update. Wendy, would you like to say a few words?
Yes, we are big on education and we really enjoy partnering with Richard and his team. Education's big. We're a management company, but we always welcome all board members, all CAMs, because the better off we all are educated, the better our industry is. We're very happy today to be with Richard and his team. There is no crazy question. We will be monitoring the Q&A. Some questions will probably be held to the end, but we'll get to as many as possible. What I will say is that if you learn one thing today, then we've hit our goal. We want you to walk away having learned something. So thank you so much for joining us today, and I turn it over to Richard to introduce his firm.
Okay, well, John, why don't you say a few words?
Hi, John Treblecock. I'm a shareholder here at Cody DeBost and Cross. One thing I think we should point out from the top is this is a legal update for the 2024 session, not 2025. Now, we can certainly touch on some of the things that came out of House Bill 913, but the governor has not signed House Bill 913, although we have every indication that he will. The reason he hasn't is simply the logistics of how the Tallahassee works, where the legislature only sends over certain batches of bills at a time, so the governor's staff can consider them. That can't just take everything at once, like drinking out of a fire hose. So he's indicated he will sign it, but this is intended to be for managers to get their credit for the 2024 legal update. But we can certainly touch on 2025 as we go.
Okay, and as John said, this is the 2024 legal update. It is available for CAM credit. If you're a licensed community association manager, submit your information to us and you will receive credit for the 2024 legal update. For homeowners, board members, there is a legal update requirement that the DBPR is preparing. This has not been qualified for that yet. I'm sure it will be, but the division has not issued the curriculum yet, so this will not necessarily apply to your credit requirement of 1 hour continuing legal update for condominiums and 4 hours or 8 hours, depending on the size of your HOA. With that, a couple other housekeeping items. This is not intended to be legal advice for your particular community. Every community is a little bit different. The documents are a little bit different, and your facts and circumstances are unique to you. So while this is a legal update, anything you take away from this, if you want to apply it to your particular community, you should talk to your current legal counsel to confirm that it is applicable to your community. With that, we're going to start off with condominiums.
Well, and before we jump in, let's point out Leanne, our partner, Leanne Bosch, isn't presenting with us today, but she is the technical guru of the three of us. And she has put in the Q&A a PDF of this material. So if you want to download it, you can go into the Q&A, download it, and circulate it as you see fit.
Thanks, John. One clarification there, it's actually in the chat box.
Oh, okay, sorry.
However, you are going, so go to the chat box to get the PDF. And if you have any questions as they go along, please put them in the Q&A box.
Okay, so we're going to start off with changes to Chapter 718, which applies to condominiums. Then we'll go into cooperatives, Chapter 719, which is very short. Then we'll flow into Chapter 720, which covers HOAs. And then there's some just general legal changes to the CAM statute and other statutes that we'll go from. I'm going to lead off here. John Treblecock will jump in as needed or when I need a little bit of a break. But to start off with here, number one, this is the 4-unit exception, the milestone study exception that applies to condominiums and cooperative buildings that are 3 stories or more in height, which came out of the Surfside disaster legislation. It originally only extended to 3-unit buildings. If you were 3 stories or less and only had 3 units, you didn't have to do the milestone study. Now, if you're 3 stories and you only have 4 units, you do not have to do the milestone study. So that's a little bit of a break. The next one, number 2, and again, this only applies to condos and co-ops that are 3 stories or more in height. If you're not that, this doesn't apply to you, but we'll get through this pretty quick. The SERS may now be waived if your building suffers a disaster, like another hurricane, God forbid, and it is unoccupiable. You can waive the collection of the structural integrity reserves for that year or the year after. Formerly, you couldn't waive structural integrity reserves, but when you're rebuilding the entire building, there's really no reason to collect the reserve. So if that circumstance does arise, you'll be able to waive the reserves for that year.
And Richard, a point we've discussed before, they won't be able to use the same SERS anymore after they've gone through something that is so dramatic that the building's not habitable. They're going to have to get in new SERS, but they may have essentially a new building. So
Right. Another thing applicable to the SERS reserve study is now within 45 days of receiving the study, you have to distribute it to all the homeowners and put it on your website. And you also have to inform the Division of Condominiums that you've obtained your SERS reserve study. So that's it. Now we're going to flow into just general condominium Chapter 718. This applies to all Chapter 718 Florida condominiums. The first one is really just a definitional change, doesn't really apply. It's not going to be legally impactful for any of you. Number two, hurricane protection. This is important. Formerly, the statute talked about hurricane shutters, the traditional roll down or slide hurricane metal type shutters that the original hurricane protection was in Florida. Now, hurricane protection is obviously much more than just the traditional shutters. You can have impact windows and doors. You can have other types of hurricane protection. So they've expanded the definition from hurricane shutters to be hurricane protection, which means any code compliant hurricane protective device. And this would also include what is becoming very popular on the coastal communities, like flood panels that you put on the first floor. That is considered hurricane protection. So they've expanded the definition beyond traditional hurricane shutters, and that will become important in a later section that we're going to talk about in a little bit. Number three, they've added the definition of what a kickback is. This came from the HOA statute a couple of years ago. They've now created a definition for a kickback, which means anything or service of value for which consideration has not been provided for an officer or director or manager's own benefit. So technically, a kickback could be considered a vendor comes to you and is soliciting you for business, and they want to give you a free I don't know, widget, whatever they might want to give you, or they give you something free. That's technically could be considered a kickback, so you have to be careful. Now, when you receive an item like that at a trade show, that's okay. Or if you receive a meal at a vendor event, that's okay too. But this is going to become more important in a couple of slides coming up. Number four, condominium within a condominium. This is a developer item, just means that within an actual condominium unit, you could create another condominium. It has no impact on your day-to-day operation. It's a developer issue. Likewise, the next one, number five here, residential and mixed-use condominium hurricane protection. Whether you have to identify in your condominium whether the unit owner or the association is responsible for the installation, maintenance, repair, replacement of the hurricane protection. So on your typical Q&A that you have every year that you give to a prospective buyer, those 10 questions that you have to answer, one of them now should be who is responsible for installing, maintaining, and repairing hurricane protection. Most often that's going to be the homeowner, but in some instances the association may have taken on that obligation and you would have to identify that. Number six, accepting kickbacks is a crime. Again, this comes out of the HOA statute. They've now ported it over into the Condominium Act, and it provides that if you accept a kickback, it is a crime. You're considered a felony in the third degree. So again, be mindful of taking gifts from vendors that are proposing to offer you services. That's really a no-no, and you shouldn't do it, and be very careful of that.
And we'll get into that in a little more detail. It is interesting to note, as Richard said, this came out of the 720, which was passed 2 years ago, and then they added it to the Condo Act, almost identically, but not quite. And any of the managers that are on that do portfolio will understand the frustration of 718 will say this, 720 says this. Well, guess what? In 2025, they made, your job even more difficult, in that they changed a lot of things in the Condominium Act, but almost nothing dealing with 720. So they're diverging even further. Anyway.
Yes. Number 7, Fidelity Insurance or Bond, as you know, or you probably should be familiar. I know the managers are. Anybody that has the ability to touch the funds of the association in a condominium, you have to have a Fidelity bond or theft bond. So if somebody stole those funds, if you do not have that, the division can now cite you and fine you for not carrying the proper insurance for Fidelity bond insurance.
And that'll be a theme of what we're talking about today, Richard, is the increased jurisdiction of the DBPR over a lot of areas, and especially in the condominium world, but also in HOA. Although, as we've seen, they've been very slow to enact some of the requirements the legislature placed on them, like the continuing education everyone's supposed to be taking. They don't quite have the staff yet to get that up and running as fast as we expected.
Right. Number 8, official records. They've clarified that email addresses and fax numbers, of all things. I mean, who has a fax machine anymore? I don't know. But they've clarified that email addresses of homeowners and fax numbers are only accessible to other unit owners as official records if that email address has been issued to the association for the purpose of official communication, which is typically not the case. It also prohibits an association from selling your email address. I was not aware that this was a problem, but apparently there must have been a problem with associations selling the email addresses to outside vendors to contact homeowners. So that is now expressly prohibited. I wouldn't have advised you to do it anyway, but apparently people were doing it, and now it is officially not allowed.
Richard, we do have a couple of questions. We could spend a little bit of time explaining what is the DBPR? What does that stand for?
That is the Department of Business and Professional Regulation, the DBPR. It regulates condominiums and managers. It's a licensing division. And
the DBPR
other things.
Covers all professional licenses like cosmetologists, et cetera, et cetera. And then the Division of Condominiums, Timeshares, and Mobile Homes manages or oversees. So when we say the division, we're talking about a part of the DBPR that oversees condominiums, timeshares, and parts of HOAs. Their authority over HOAs is not as extensive as that over condominiums. And another question we often get is, how do we know for a condominium or an HOA? Well, condominium is governed by Chapter 718 of the Florida statutes. And if you look at your declaration, it should say Declaration of Condominium. Well, HOAs are under Chapter 720, and it'll probably say Declaration of Covenants, Restrictions, something along those lines. And then, of course, there's also Chapter 719, which often gets forgotten. That's dealing with cooperatives. We will be covering cooperatives today, but essentially everything that happened to cooperatives in 2024 is the same as what happened with condominiums.
Right. Now, number 9 on this slide is important because it's going to create a greater burden for y'all. Number 9, for condominiums, it says all invoices, transaction receipts, or deposit slips that substantiate any receipt or expenditure of funds of the association are now official records, as are building permits and board certification course certificates, which the last 2 are fine. But if you read this, what this literally means to me is if you go to Home Depot and you buy a light bulb for the clubhouse and it costs you $1.50, you have to keep that Home Depot receipt as an official record. I mean, this is really kind of crazy. It's a lot of little pieces of paper. I'm not clear, and maybe John has some thoughts on this. If you used a credit card, would the credit card entry be sufficient, or do you literally have to take that cash register receipt and save it? That's what it appears to say. That's a lot of paper.
These days, you can usually have it emailed to you. So
yeah. But anyway, that's
Wendy, I'd be curious as to how you're seeing this implemented, as far as like our associations paying to have everything scanned and uploaded to a website, because that's one way you can deal with these things. If you put them into your website behind an owner portal, you can, I think that's the best practice in the way we're moving towards in the future, but there's still boards that
Sure.
aren't aware that this deposit slips down to that level of minutia is an official record that owners can have the right to inspect.
What I can say is it pertains to credit cards. We use Sync software, but regardless of the software you use, our head of accounting is a certified fraud examiner. And so she always drills it into our heads. The easiest way to commit fraud for managers and board members is through credit cards. So when we provide the statement for an association credit card, it will say total amount due, whatever the case may be, $507. We can't approve it in the system without getting the receipts. Now, is there going to be a lost receipt every now and then? Of course there is. But when you have some charges like Amazon, it could be personal, it could be for the association, so we look at the receipt. However, what we're really looking for is not the Amazon charges so much as maybe a 3-day vacation in Orlando that was paid for on the credit card. But I do suggest, no matter what software you use, you keep the receipts and keep it with your accounts payable, that you can present it for the audit or present it for any records request. So it is a best practice. We don't really put it on the website. We put the owner financials up there. But if someone did a records request, we would have it.
Okay,
So I think
good.
it's a good idea just because we've seen it in the news a couple times that there's been fraud and it's usually been through the credit card.
Right. Number 10, official records now expressly have to be kept in an organized fashion, which I think normally as a good business practice, you would keep things organized. But I know in the old days when people would make voluminous records requests, you often would just refer them to a big box and say everything's in there and it's just a disorganized mess. You really can't do that anymore. You have to have the records in an organized fashion so that, insurance would be in a file called insurance. I mean, that's pretty logical, but now it expressly says that you have to do it. The next part of that is if your records are lost or destroyed, you have to make a good faith effort to recreate the records or find them. I mean, after the hurricanes, a lot of records were out in the Gulf of America. And you couldn't find them. But I think what that means to me is if your insurance policy gets lost or destroyed, you call up the insurance company and you get another copy of the official record. Obviously, if, as John suggests, and is kind of the modern practice, that you keep everything in the cloud or on the computers these days, that's not going to be as big of a problem. But if your box gets burned up in a fire, you can't just say, oh, well, those records are gone. You have to make a good faith effort to find the records. Number 11, if records are available on the association's website or a downloadable mobile device, you can fulfill a records request now by referring them to the website, which is becoming much more common. The old days of having them set a meeting to come in the office and sit at Wendy's desk for 8 hours and look through boxes, that really is still an available method. But, obviously that's intrusive. And so these days, the more you put on your website, you can simply fulfill the records request by pointing them to the website and say, go to the website. Or alternatively, you can just send them the records via electronically. So that's good.
I did have some associations where, as you said, the records ended up out in the Gulf of Troublecock. That the division did come in and did ask questions. What steps did we take to try to recreate them or to obtain them? I'm like, well, I don't. Those would have been exposed to Cat 3 water. I don't know who's gonna go peeling through boxes, even if they had stayed. But out where I live, whole bottom floors looked like garages. So and that's usually where physical records were kept. But the division will come in and ask those questions, but they're also understanding, and I don't think that they were wanting to pick on any hurricane victims, but they had to do their due diligence.
Right. Number 12, this is more burdens for the manager and the board members. When somebody makes an official records request and you respond to it, you now have to provide them a checklist, which the checklist itself is also an official record that you must maintain. The checklist that I've seen is if someone makes a records request that says, I want X, Y, and Z, then you basically provide them a receipt that says what you did. Here, you'd list on the piece of paper, record X, provided to you or not provided, and why. Why would you not provide it? Maybe they asked for the credit report received for the tenant next door. Well, certain official records are not available to homeowners. So on that, in that example, you would say you asked for the credit report for the lessee next in the unit next to you, not available pursuant to law or something. But you have to identify the records that you did respond to and give them, and you have to identify the records that you did not give them. And that checklist itself is an official record that must be kept for 7 years. So it's another piece of paper that we're all going to have to comply with.
But having that checklist, it does serve a purpose in that it creates a rebuttable presumption that you have complied with the official records. So if they could show that you're lying on the checklist, then, you know, that would be a problem. But if they say you didn't comply and you can show a judge, no, or DBPR, look, no, we have the checklist, the burden will shift to them to prove that you did not comply.
Right. Number 13 is again ported over from the Chapter 720 laws that were amended a couple of years ago. It basically, in a nutshell, says that if you intentionally deny access to records or knowingly, willfully, and repeatedly violate this paragraph, it is a criminal act. And what that means is if 2 times in a 12-month period you knowingly, willingly, and intentionally deny them access to a record, that is a criminal act. If you intentionally deface, destroy, or unlawfully change a record, an official record, to avoid some kind of criminal allegation against you, that is basically tampering with records or refusing to produce records in order to conceal bad acts that you've done. That is now itself a criminal violation of the law.
Of course, it was a crime anyway. Covering up fraud is a crime, but they felt like they had to put it in here. It's just so some of you, if you're not aware, a lot of this came out of just a massive scandal over in the East Coast. The Hammocks HOA, which is the largest HOA in the state, it essentially became a criminal cartel. I mean, for years, it was being run with board members creating fake jobs to give to cousins and stepbrothers, and unfortunately, the association council seemed to be in it or was enabling it. They were abusing elections, suspending your right to vote. So the legislature felt like they had to step in and create the Homeowners Bill of Rights in Chapter 720. So a lot of this was then ported over into 718. Richard, one thing I would point out is I think for condos, at least in the new legislation, they no longer have the second 2 times.
Right.
Which, you know, we've discussed before. When they say twice for a manager, does that mean twice at each property, or could it be once at this property, once at this? Hopefully no managers are purposely doing this and are you know, and neither would boards. But sometimes boards being busy and your volunteers, you may not realize that these records requests need to be complied with within 10 working days or 10 business days. So now that there are potential criminal penalties, I would make sure that your team is getting that done. Now, on the other hand, we don't want to scare you. I don't think any local law enforcement is going to come crack the whip down on you if it's an innocent mistake. But if there is some kind of malicious intent or gross negligence, then, you know, that would be concerning. And your D&O insurance probably won't cover criminal convictions, so you'd be on the hook for your own attorney fees.
Yeah, the real problem I see with making these things criminal acts is, while it's very unlikely you'll get prosecuted for them or you actually really did intentionally commit the crime, it gives that particular homeowner, which we all have one in our community, that will make the allegation and will point to the statute and said, oh, you intentionally didn't give me the record twice in 1 year. Although that's been removed from the 2025 law, and it gives them the basis to make the allegation, and now you're going to have to defend yourself against this completely ridiculous charge, and it's basically a weaponization of the statutes, which sounds good on paper, but in reality, we know that 99% of the people that will use this law there's no basis for it, but they will make the allegation because now they have something to point to, and that's really disheartening to me, that the legislatures really think that this, there are bad acts that go on out there, but there's always laws on the books that already cover these kinds of things. So adding more to them
Yeah.
really is just makes our life
When those
harder as a
legislators go
manager.
to their town halls, the people who love their boards and love their managers are not the ones showing up at those town halls to speak up loudly. Richard, we do have a few questions.
Okay.
One has been repeated a few times. How long would you have to keep these receipts, or how records retention timeline?
Well, certain records are kept forever, certain records 7 years, certain records for 1 year. I don't know what category this would fall into.
I think
Probably
it's
the
a default
7 year.
7 year.
Yeah, the 7 year category. But it depends.
Can a condominium charge for a copy of these records?
Yes, you can charge, you should have an official records request policy, and while the statute doesn't mention it, following Chapter 720, there is a basis for charging, 20 cents a copy, etc.
Are there any free copies before that 25-cent kicks in? Or
Not under the Condominium Act, and the HOA statute says if you have a copy machine on site, you are allowed to make up to 25 copies on that copy machine. It doesn't say you don't have to pay for them. Some people interpret it that way, but
you just mentioned having an official records policy request, so that ties into the next question. Is an email from a resident an acceptable request, or should the request be sent certified to the management company?
if you do not already have an official records request policy saying that email requests are not valid, in my opinion, an email request is a valid records request. But number one in your official records policy should be, we do not accept email requests. It's simply too easy to fire off 20 emails at 4 a.m. And then the manager walks in the next morning and has just all these emails, and frankly is probably going to miss one, and then, oh, you didn't respond to my official records request. So your official records request policy should say that the records request has to be sent certified mail or delivered with a receipt so that you can properly document it, and that cuts down on the voluminous email records request. But without that policy, I think an email request for records is an official records request that should be complied with.
Yep. Yes. Work with your counsel to their opinion, and have them draft a records request policy if you don't already have one. That's one of the policies I would urge every association to have, as well as a policy about board meetings and how long people can speak. Reasonable regulations are things that you should adopt, and your counsel will be happy to work with you on
Right.
that.
Number 14, building permits are official records. That's kind of obvious. Number 15, this is an important change. Number 15 here says that as a condominium, and actually as an HOA, this is also in the HOA statute now, you could waive the year-end financial reporting requirement every year on a vote of the owners. So if you were supposed to do an audit at the year-end financial reporting level of $500,000 or more, you could waive that every year. You could do that. Now, while the law is very awkwardly worded, what it essentially means is you now can only waive your statutory level of financial reporting every other year. So if you're supposed to do an audit every year because your receipts are $500,000 or more in a condo, co-op, or HOA, you can now only waive that audit every other year. On the off year, you have to comply with the statutory level of financial reporting, which, depending on your receipts for the year, could be an audit, could be a compilation, could be a review, or could be a internal report of receipts and expenditures. So that is kind of a big change. You can only waive your year-end report every other year now. Number 16, debit cards. You're not allowed to have a debit card. This is again from the HOA statute. You can have an association credit card, but you cannot have a debit card. I think the logic behind that was, or I'm told from bankers, with a credit card, you can dispute the charges, and you have a period of time that you can dispute the charges if you don't think they were proper or they were fraudulent. On the other hand, with a debit card, there is no ability to dispute the charges. Once that debit card transaction goes through, the money is gone. So that's why they don't want HOAs and condos to have debit cards in their possession. So be mindful of that.
Well, and also pay attention to the last part of that where it says, if you use a debit card for anything other than a lawful obligation, that's the crime of theft. And a lawful obligation is something that has been, quote, pre-approved by the board and is reflected in the minutes. So if you use a debit card for anything that is not in the minutes already, then you've committed a crime. So don't use
Yeah,
debit
but
card.
I laugh at that statute because the first part of it says you can't have a debit card. Okay, just leave it at that.
Right.
Then it says, but if you do have a debit card, which you're not supposed to have, and you use it for an unlawful purpose, that's a crime. So it's kind of odd. The takeaway is you can't have a debit card. Don't use a debit card. Number 17, if you're formally, if you were a condominium with 150 or more units since about 2020 or 2021, you have to have had an official association website and put certain documents on that official website. Now, as of January 1, 2026, if you're 25 or more units, they've lowered the number. If you're a condominium with 25 or more units, as of January 1, 2026, you must have an official website and you must post the statutorily required documents on that website. The statutorily required documents are some of your official records. It's not all the official records, but a large portion of your official records have to be posted on your website. Most of you probably already have a website, but now legally, if you're 25 or more units by 2026, you have to have the official website. Formerly, it was 150 or more units. Number 18, interesting. This is now, again, we're in condominiums only. This is chapter 718. In a residential condominium, as opposed to a commercial condominium, if you have more than 10 units, the board of directors has to hold a board meeting at least one time every quarter. That's 4 times a year. Now, most condominiums, I would dare say you probably have monthly meetings or at least more often than quarterly. But if you're 10 units or more, you have to hold at least one meeting every quarter of the year. And at that meeting, you have to allow the owners to ask questions on anything they want. The former law said, and it still says, that owners can comment on any item on the agenda. So obviously, if something wasn't on the agenda, they're not allowed to comment on it. But at these 4 quarterly meetings, they now can ask questions on anything, even if it's not on the agenda. But keep in mind, they can ask the question. Your board does not have to answer the question. There's no affirmative obligation to answer the question, but you have to have 4 meetings a year where you ask the owners, do you want to ask us any questions? And you have to do that. That's now a requirement.
Richard, we have in the comments, anonymous attendee, obviously, says they are on the board, but the board and the vice president are related and they will not have meetings and they do not allow the secretary to have any duties. So how do they seek redress if for a condominium that never has any meetings?
Well, if they're not having any meetings and they're not doing a board action by unanimous consent of all directors, which is another method,
Which they obviously wouldn't because this is a board member.
they're very obviously, conducting business without meetings, and that is a violation of the statute. And you could complain to the division. You could file a complaint that the board is taking action without properly noticed meetings, and they would probably investigate. And if it's determined to be the case, they could potentially impose sanctions, financial penalties. Okay, number 19, board meetings relating to contracts for goods and services. If the board is considering a regular or special assessment at a meeting, and at that same meeting, they're going to approve a contract, you have to attach the contract to the agenda, which would be posted on your property. So when this law first came out, I actually interpreted it to mean at any board meeting where the board of a condominium association is going to consider approving a contract for goods or services, you had to attach the contract to the agenda. But after a while, and talking to other lawyers, a closer reading of the statute really limits that. It's not as bad as it sounded at first. What it says really is, if at the meeting you're going to adopt the association budget or a special assessment, and at that same meeting you're going to approve a contract, the copy of the proposed contract has to be attached to the agenda and the notice of the meeting. So keep in mind, you typically aren't going to have a lot of meetings during the year, board meetings where you're approving the budget. That's a one-time meeting only typically. And you're probably not going to have very often meetings where you're adopting special assessments. So you really don't have to worry about this. You have to attach the contract to the meeting agenda unless at the same meeting you're approving the budget or you're adopting a special assessment. So the law at first blush was very burdensome, but a closer reading suggests you do not have to attach the contract to most board meeting agendas because you're not going to also at the same meeting be adopting the budget or a special assessment. Number 20, this is the new board certification law that most of your directors probably are aware of. The former law, which is a whole nother course. This is not the board certification course, but for condominiums now, the law says within 90 days of becoming a board member, appointed or elected, you have to now take a 4-hour board certification course. And it was formerly a 2-hour course, but now it's a 4-hour course. Formerly, you could sign a certificate in lieu of taking, or a certification in lieu of taking the course. Now you have to do both. You have to sign a certificate that says you've read and understood the documents and you follow them, and you have to take the board certification course and get a certificate acknowledging that you took the course. You have to do that within 90 days. If you've done it, it's good for 7 years of your service on the board. There's a similar law for HOAs, which we're going to discuss in a little bit, but it's not exactly the same, but it's similar. So this is the board certification course. If you took the board certification course for condominiums prior to July 1, 2024, or you signed that certificate prior to July 1, 2024, you don't have to take the new course until June 30th of this year, which is basically in 19 days from now. So if you haven't taken that condo board certification course, you need to do so. If you don't take the course, you are suspended from the board until you do take the course. We offer the course, as many other law firms do. We offer it on live webinars, but we also have on our website, you can go to gadclaw.com, and you can take a on-demand course at your leisure, and we'll issue you the certificate. So
We had a question in the chat. What happens if the entire board just refuses to take the course?
Then the Condominium Act says that board is suspended. And if you have no board, then you can't do anything. And after 30 days with less than a quorum of the board seated, anybody can apply to the state for a receiver to be appointed. So you don't want to do that. This is not something to play around with. You've got to take that course or you're suspended from the board.
Until you take the course.
Until you take the course. So number 21. This is a good thing. This is number 21 also has come out of what John mentioned of the HOA over in Miami that was the corrupt organization.
The Hammock.
Problem with that organization was for years, those directors had been charged with criminal acts, but they had not been convicted. And if, the legal system is a slow process. So all the while that those board members had been charged with fraud and theft and corruption, they had not been convicted. So they stayed on the board for years and years, and they had lawyers fighting the system to keep them from being actually convicted of these crimes. So all the while they stayed on that board, they continued to commit the crimes. And that was just really outrageous. So even though everybody had charged them with the crimes, they hadn't been convicted. So they stayed on the board and continued to commit the crimes. Finally, they got convicted and they were off the board. This new law says, if you're charged with these crimes, indictment of forgery, theft, destruction of records, if you're charged with it, you're off the board until you're found innocent or you're found guilty. So while this kind of goes against the American system of justice, which is innocent until proven guilty, what this basically says is if the state charges you with one of these crimes, even though you haven't been convicted and you may be found to be innocent later, you can't stay on that board and continue to perform the bad acts. So I actually think this is a good thing to keep the fox out of the henhouse, so to speak. Number 22, I'm not going to go through this in detail, but again, this is exactly ported over from the HOA statute, again, out of the criminal activities over in the HOA in Miami. This is brought over. It basically prevents fraudulent voting activities. You can be convicted of a crime if you commit any of these acts in trying to influence the election. Now, again, unfortunately, I think this law will be used improperly by people that will say, well, they coerced Mrs. Johnson to vote yes in the election or vote no, on this director or whatever. They will make these allegations, but you have to be, commit one of these, basically strong arm somebody to, provide them money to vote a certain way or threaten them physically to vote a certain way. These are all criminal voting activities. You can still advocate your position and advocate to vote for this candidate over that candidate, but you can't try to coerce or threaten people or bribe people to vote in the election in a particular way. Or
Yeah,
that
it really is
considered a crime.
unfortunate the legislature had to even consider this. I mean, people just don't do dumb things for a unpaid volunteer position.
Right. Number 23, this is an important new part of the hurricane protection law. Like I said, they expanded the definition of hurricane protection to include anything. What this law now says is if a majority of the total voting interest vote, they can make the association take on the obligation to purchase and install hurricane protection for all owners as a common expense, or, and this is probably the more common one, or on a majority vote of the total voting interest, the owners can force all owners to install hurricane protection of the type, style, and technology that the board approves at their expense. So where this would come into play is, let's say you have a high-rise condominium and 80% of the unit owners have installed hurricane protection, okay? But 20% haven't. They've said, I don't want to spend the money. I don't care. I'm not going to put up hurricane protection to avoid the windows from getting broken and potentially dumping water down through the whole condominium stack. Now, on a majority vote of the total voting interest, the owners can force those owners who have not voluntarily installed hurricane protection, they can force them to do so at their expense. So that's something to keep in mind. I don't know a lot of condominiums that are choosing to take on the obligation to install hurricane protection as a common expense. It's almost always been left up to the homeowners to voluntarily do it. But obviously, if 80% of the units have the hurricane protection and 20% don't, that 20% can severely impact the rest of you because the wind and the rain is going to get in through those windows that are not protected. So this is something to keep in mind that you may want to look into with your legal counsel. Number 24, statute of repose. Statute of repose is basically a statute of limitations for hidden defects in construction claims. They've just clarified that it runs from the date of turnover from your developer. So it's basically involves construction defects, hidden construction defects, as opposed to unhidden or patent construction defects. There's a different statute of limitations. If you have a problem with, you hired a contractor to put on a new roof or something, and you believe that the roof has not been put on properly, there are time limits in which you need to bring those claims, and you should talk to your legal counsel as soon as you discover what you believe to be a defect in the construction that you hired them to do. You need to talk to your legal counsel about your legal obligation to pursue those in a timely manner. Number 25, SLAPP suits. I'm going to let John talk about this. This is his favorite subject. And so I will let John talk about SLAPP suits.
Richard says that because in another life, I was in the legislature in Oklahoma, where I'm from. Go Thunder.
Go Pacers.
Richard's an Indiana guy, and I'm an Oklahoma Thunder guy. So there's a little bit of rivalry this week. One of the pieces of legislation that I passed was a SLAPP suit combining statutes from all over the state into what kind of has become a model piece of legislation. A SLAPP suit stands for Strategic Lawsuits Against Public Participation. And it's really when a party with the power imbalance, like a large corporation, or in this case, in the legislature's eyes, a association, condo or HOA, tries to take away your First Amendment rights to participate in public forum through litigation. So the legislature, this has always been in on the statute for quite some time, but they've strengthened it, I guess you could say. So it makes it clear that associations cannot use association funds to try to basically shut owners up or discriminate against them for speaking out about lawful interests. So an owner can then raise retaliatory conduct, and they can get the lawsuit thrown out in an expedited manner and get triple damages. So there is a definite need to work with your counsel, and your counsel should be aware of this and will caution you about this. What on the other hand, the legislature may have gone too far because associations are going to be afraid to exert their rights against bad faith owners who are weaponizing the tools that the legislature has given good faith owners. They're going to use it in bad faith. But again, you're going to have to work with your counsel to determine if someone is in good faith done any of these things that are listed. Like, obviously you should not be going out and suing someone because they went to the local municipality and reported a code violation. You shouldn't have been violating the code in the first place. So you shouldn't be trying to take away their First Amendment rights or discriminate against them in other ways.
Yeah, I think the real practical impact of this is really that last sentence there on the page.
Yeah.
A condominium association may not expend association funds in support of a defamation, libel, slander, or tortious interference action against the owner or any other claim against the unit owner based on the conduct described in number 3. The practical example is this, and we get this all the time. The crank unit owner goes on social media and bashes the board and claims the board is doing illegal things, and we constantly get the board coming to us saying, stop them from doing it. Traditionally, while we didn't have a lot of tools to stop an owner from doing that, what we would write would be a cease and desist letter. And we would say, stop telling lies about the board on social media, or we're going to sue you for defamation, or we're going to sue you for what's called tortious interference in a contract, which means you keep interfering with our roofer and the roofer's going to walk off the job. So we're going to sue you because you've interfered with our contractual relationship with our roofer. That was a very common letter to write. And while it was marginally effective, it did at least let us rattle the saber a little bit and threaten the owner. Now we have to be very cautious about writing these letters, in my opinion, because of this SLAPP lawsuit law, which is basically going to say, look, I have a legal right to claim that the roofer's illegally performing the work on the roof. It's my roof. I own part of that roof. I have a legal right to claim that they're doing bad acts. And now you're using association funds to try to intimidate me from asserting my legal good faith belief that the roof is being put on illegally or improperly. So we have to be very cautious about writing those letters now. And frankly, that while they didn't do a lot of help in the past, it now opens the board up to charges of violating this law. And so we kind of caution against doing that.
Now, notice it says associations cannot use the funds. If you feel like you've been defamed or libeled or slandered, you certainly are allowed to hire your own private counsel and pursue that action. But the association cannot use its funds to pursue that.
Number 26, electronic voting. What this says, and this is also in the condominium, cooperative, and HOA statutes as of 2024, if your board has authorized electronic voting and utilized electronic voting, in the past, you could say, well, for the next year, we're not going to use electronic voting. Now the law says once you offer electronic voting and people accept it, you have to continue to offer electronic voting. You cannot take it back. Hopefully this is a move into the direction of always using electronic voting because it's much more efficient, safe, saves trees and postage and things. So I'm a big proponent of electronic voting. But now the law says once you offer it, you can't take it away. But I would hope most of you would try to offer it. Number 27, director conflict of interest. If you're doing business with a director or officer, this clarifies that the attendance of the director or officer at the meeting of the board where you're going to consider doing business with that board member can still attend the meeting, still counts towards the quorum to establish the board meeting, simply can't vote but they do count towards the quorum to have a lawful meeting to consider doing business with them. Number 28, they've added to the suspension of voting rights law. In the past, if an owner was more than 90 days delinquent in the payment of any monetary amount in a condominium, you could suspend their right to vote in the election. It's very complicated to do that. You now have to, at least 90 days, before the election, you must notify the owner of the member that their voting rights may be suspended. They've made it very difficult to suspend voting rights. And again, this comes out of the bad acts of the HOA over in Miami. One of the tactics I'm told that they used in that association was they would put a fraudulent charge on the owner's account. And then they would say, well, you owed us $25 and now it's more than 90 days. We're suspending your right to vote. And they did this to a lot of owners that were attempting to vote these bad board members out of office. But they fraudulently put these charges on their account and said, you're delinquent, you can't vote us out of office. That was a tactic they used. So now the legislature's made it very difficult to suspend voting rights. There's a lot more than just this, but you have to give them a 90 days heads up and you have to do certain other things so that you cannot.
It's very rare,
Yeah.
you agree, Richard, that someone's
Yeah.
suddenly going to pay up whatever they haven't paid just so they could participate in their association election.
Yeah.
If they were a passionate owner who cared about the well-being of the association, they would be current on their monetary obligations anyway.
Right.
We have a few questions.
Sure.
One, a lot of people are asking about a recording. Wendy, are you able to send that out, or is that something we would do, Richard? I don't know the logistics of who.
I don't know. We could probably somehow we can get it to you.
And we
We
can
all-
work with Sarah and get it out.
Okay.
Some people, how do we find out who has taken the 4-hour course? Well, the certificates become an official record, and any owner can inspect those. And I would say all board members, doing due diligence should make sure everybody is compliant. But you don't have to take, and I don't know if we touched on this, you don't have to take a vote of the board for those board members to be suspended. By operation of law, they are automatically suspended. We have a question. What about owners engaging in retaliatory conduct against board members?
I wish I had a magic wand. John touched on it. If you personally feel that they've defamed you or slandered you as a board member, you need to get your own legal counsel and pursue that. It's very difficult for us to pursue it on behalf of the association.
What are the procedures to have the state take over a condo? Is that a good option for a board that is unmanaged? Well, the state will never take over. As Richard mentioned, there would be a receiver. And a receiver is often a retired judge or attorney who is going to charge very high rates every hour to basically run your association. So it's never optimal. The Hammocks HOA that we keep referring to was put under receivership. And while I don't remember the embezzlement amount, it was like $3-4 million over several years.
Yeah.
The cost of the receiver has surpassed that by
Right. They spent more money on the receiver organizing things and getting it back in order than they lost. So it's kind of was shooting themselves in the foot, so to speak. We're almost finished with the condo section here. Number 30, the Division of Condominiums has increased jurisdiction beyond what it formerly had. And they now can investigate you for fraud, embezzlement, theft, or other criminal activity and refer you to the state's attorney's office if they believe they found it. Number 31 is important, My Safe Florida pilot program. This is a program where the state has money set aside that if your condominium wants to harden the building by installing hurricane protection devices or hurricane windows or hurricane doors, or make the roof more hurricane resistant, you can apply to the state and get money, which is like a dollar for dollar match up to about $175,000, I believe. This is only for condominiums, I believe, within certain number of miles from the coast. I think it's 20 miles of the coast of the coast of Florida. You can apply. So if you're thinking of putting on a new roof, or putting in hurricane windows or doors as an association, think about the My Safe Florida condo program. It did fill up very fast and the money was expended immediately. They only set aside like $30 million or something and it went real quick. But they've re-upped it this year, and I think it's become so popular that they're probably going to continue to fund it. We have a lawyer in our office that is can walk you through the program, or certainly other lawyers should be familiar with it. There are certain hurdles and owner approval requirements to comply, but it's essentially free money up to $175,000 if you're going to take steps to harden your building. So keep that in mind. The question that always comes up, well, what if we put on a new roof last year? Can we get reimbursed? No, you cannot do the work and then get the money. You have to go through some prerequisite steps and then get approved, then do the work, and then you get the money. So that's essentially that. Number one, the only thing they changed for cooperatives was that law about electronic voting. If you offer electronic voting in your cooperative, you are now obligated to continue to offer electronic voting forevermore.
Here's a question about electronic voting. Does
Sure.
electronic voting need to be added to the condominium declaration, or can it just be added to house rules?
No, and that leads us into one of the new changes for 2025. Under the current law, you do not have to amend your governing documents to offer electronic voting in a condo, a co-op, or an HOA. You must hold a 14-day mailed and posted notice special board meeting and adopt an electronic voting resolution. So it's a vote of the board. In the new 2025 legislation, which I believe only applies to condos, they've done away with the 14-day special notice requirement, and the board can adopt electronic voting on a regular board meeting. But the bottom line is no, you do not need to amend your documents to offer electronic voting.
I believe it also allows I forget what the threshold of owners to petition to force the association to use electronic voting. But what I found interesting is it says, and they have to begin within 21 days. So that's not very realistic to go out and find the vendors and get it. So we'll see how that turns out. But the option is there for owners to force associations to use electronic voting in
Okay.
condominiums.
Right. So now we're going to talk about Chapter 720. This applies to homeowner associations. And again, some of the laws are similar, but they're slightly different. Why they continue to do this, I guess it's to make John and I and Wendy's job and you other managers and board members' jobs harder. But that always comes back to the critical question. Are you a condo, a co-op, or an HOA? If you don't know the answer to that question, you need to find it out because it directs you differently in each statute under certain areas. So that is a threshold question before any lawyer can answer your questions. We have to know what you are. So number one, similar to the Condominium Act, now as of January 1, 2025, which was about 6 months ago, if you're an HOA with 100 or more parcels or homes, you have to have an official website and you have to post certain documents on that website. If you're under 100 homes, you do not have to legally have the website. You could have it if you want. But if you're 100 or more, as of last January 1st, you have to have that official website. So if you don't have it, and this is your category of 100 or more homes, you need to go out and get that set up and post the proper documents on it. Number two, inspection of records. Again, this is similar to the condo law about knowingly, willfully, and intentionally denying access to records or destroying the records with an intent to avoid prosecution for criminal activity. It is a criminal violation of the law, similar to what we talked about with condominiums. Number three, subpoena of records. If an association receives a subpoena from law enforcement, they have to comply within 5 business days to provide the records. It says, and an association must assist a law enforcement agency in its investigation to the extent permissible by law. This comes up a lot when the law enforcement wants to see the gate entry log or they want to see the video monitor at the clubhouse to help investigate crime. We always encouraged boards to obviously cooperate with law enforcement. This essentially says you must cooperate with law enforcement. Okay, number 4, audited financial statements. First of all, this is similar to the Condo Act. Whatever your level of financial review is that's required, based on your level of receipts for the year. You can only waive every other year now. Just the same law that I talked about before. You can only waive your year-end financial report level of reporting requirement every other year. It also adds, the second paragraph here, adds a little wrinkle. It now says if you're an HOA association, regardless of the level of your financial receipts during the year, regardless of how much money you take in, if you're 1,000 or more parcels, you have to do an audit every year. Presumably, you can still vote every other year to do it. So there are large associations that have very few expense items. They might have a front sign at the front gate, or not even a gate. So I know large HOAs that might have assessments of very little money. They're not even near the $500,000 level for financial audit requirement. But so even if you're a large association and your budget's only $100,000 a year, you still have to do an audit of that budget that year-end financial report every year. You have to do an audit unless you vote every other year to waive the audit. So it's not based on the level of your financial your receipts. It's based on if you're 1,000 or more homes. Number 5, again, they already had this no debit card law for HOAs. They've had it for a number of years. They've just expanded it here. Again, the bottom line is you can't have a debit card if you're in an HOA. Number 6, requirement to provide an accounting. This is a new law. This says that if an owner requests a copy of a detailed accounting of their ledger, basically they want to see their assessment ledger, and you do not provide them that assessment ledger showing the debits and credits on their account within 15 days, if there happens to be a fine listed on their ledger, the fine is waived, okay? I guess this law came about because putting fraudulent fines on people's accounts, people want to see it. So if you get a request in an HOA for a copy of your homeowner's account ledger, you have to provide it within 15 business days,
Yeah.
or the any fine that is listed on that account is off.
And they can only do that every 90 days. So there is some
Right.
protection that they can't abuse it. So I think that's a good check and balance.
Sure. Okay, number 7 is the new board certification requirement for HOA directors. While it's similar to condominiums, it's unfortunately not exactly the same. What it provides is within 90 days of becoming an HOA board member, elected or appointed, you have to take the board certification course. But you do not have to sign the certificate. Before, you could do either or. Now you can only take the course. But in a condo, you have to do both. You have to take the course and sign the certificate. But in an HOA, you only have to take the course within 90 days. If you don't take the course, you're off the board until you do take the course. Unlike a condominium where the course is good for 7 years, in an HOA, your course is only good for 4 years. If you were on the board of directors prior to July 1, 2024, which is the effective date of this law, and you already took the course or signed the certificate, you do not have to do it again for 4 years. Unlike a condo, which says you have to do it by June 30th. So in any case, in addition to that course, in addition to that board certification course, if you're in a HOA with less than 2,500 homes, you now also have to take a 4-hour continuing education course every single year. In a condo, you only have to take a 1-hour course every year. If you're in an HOA that has 2,500 or more parcels, you have to take an 8-hour continuing education course every single year. Again, the division has not, the DBPR and the division have not developed the curriculum for these courses, so we cannot provide that course to you. If we can retroactively with this legal update, we will certainly try to do it, but it's quite possible you're going to have to take the legal update again in order to qualify. Again, this is not of our doing. This is the division's, not being able to put the course together just yet. As soon as they do that, we will notify everybody and we'll have these courses as webinars or potentially live in person as well. Number 8, again, they've created a definition for kickbacks in an HOA, which is the same as condos. Number 9, removal from the board for a criminal act. If you are charged with a criminal act under the statute, you are removed from the board until you are found innocent or guilty. Again, this is similar to the condominium law and comes out of the criminal activity over in Miami. Okay, number 10. Okay, they did a lot of things here in number 10 for Architectural Review Committee or Architectural Review Board. The ARC board must reasonably and equitably apply and enforce all the ARC standards equally against all owners. Okay, that kind of makes sense. No selective enforcement in enforcing them. An association or an architectural review committee or other committee may not enforce or adopt a covenant, rule, or guideline that limits or places a requirement on the interior of the structure that is not visible from the parcel's frontage or an adjacent parcel. What this effectively means is your ARC authority in your HOA does not apply to improvements done inside the home that cannot be seen from the street. Kind of makes sense. And it does make sense for a single family home, detached home. You don't really care what they're doing inside. But as some of you know, there are HOAs under Chapter 720 that are attached villa units. You're attached to your neighbor's unit. You share a common roof. So while this statute kind of makes sense for single family homes, what about the person that wants to make significant changes inside their attached villa home that, much like a condo, that could affect the neighbor? You don't have ARC authority over that. That's again, I think it's the legislature not really fully thinking out the ramifications of a law that kind of makes sense in one circumstance, but does not apply to all circumstances for all HOAs, because not all HOAs are made up of single-family detached homes. Many of them are attached villa or coach home type communities with shared roofs, shared walls, shared foundations, etc. So again, another one says that in this same law, you cannot impose a rule that requires the approval of plans and specifications for central air conditioning, refrigeration, heating, or ventilating system by the association or any architectural or construction improvement, or if such system is not visible from the parcel's frontage or an adjacent parcel or adjacent common area. So if you can't see the air conditioner, you cannot have the ARC guidelines apply to the installation of the air conditioning system outside the home if it can't be seen from an adjacent parcel, which is pretty rare. I think you're going to be able to see the air conditioning from an adjacent parcel or common area. Number 11, if the association denies an ARC application, this makes sense. You must specifically cite the ARC rule that you're relying on. You cannot just say, you submitted an application to do X, denied. You can't do that. You now have to say X is denied because Section 2.1 of the ARC guidelines says X is not allowed. For example, you submit an application for a metal roof, but your ARC guidelines say you cannot have metal roofs. Then you would say your ARC application is denied because Section 2.1 prohibits metal roofs and you cannot have a metal roof. You have to specifically say why you're denying it and what section of the ARC guidelines you're relying on. Makes sense. I think most associations did this anyway, but just keep in mind that that's what it's required.
Yeah, that level of specificity is the key. You can't just blanketly deny it or, just say the declaration says you can't do this. Like Richard said, you have to go to the exact provision in your governing documents.
Right. Now, number 12 is important here, and we'll move it up here. Number 12, hurricane protection in an HOA. And this law has been misconstrued and misinterpreted by roofers for their own benefit. So it's a little bit complicated, but let me explain it. Number 1, what the law says is the board for an HOA must adopt hurricane protection specifications, just like a condominium. So you have to adopt what type of shutter or other hurricane protection that you will allow a homeowner to install on their home, including roofs, okay? Roofs can be considered hurricane protection. So this comes into play now with metal roofs versus traditional barrel tile or other types of roofs. It's not uncommon for an HOA ARC guideline to say no metal roofs. If the entire community is made up of terracotta concrete barrel tile, and that's the ARC guideline, and you don't want a metal roof that, while maybe a good roof, will look totally different than the scheme of the entire community, okay? It will stand out. That's what ARC guidelines are for. Typically they want uniformity, particularly in the area of roofs. So what the roofers are telling you is the new law in Florida prohibits your HOA from preventing a metal roof, no matter what your guidelines say. That is not what this law says. What this law says is you have to, the board must define and adopt hurricane protection, including for roofs. If you don't adopt a hurricane protection standard for a roof that might say it must be terracotta tile and must be adhered and affixed to your roof in this fashion in conformance with the Dade County Hurricane Protection codes. If you don't have that and limiting it to terracotta roofs that meet hurricane protection standards, then you could have a metal roof that meets hurricane protection standards. But if you want to prohibit metal roofs and keep your terracotta roofs standard, you need to state that as your hurricane protection guideline, that for roofs, it's terracotta roofs installed according to the Miami-Dade Hurricane Protection Code or whatever the applicable code is. Otherwise, they could put in any other hurricane code compliant roof, including metal roofs. So what the bottom line is, the roofers are telling you you cannot prohibit metal roofs that meet hurricane guidelines. That is untrue. You can prohibit them if you limit the hurricane protection standards to a certain type of other roof other than a metal roof. So this is an example also. I actually Googled this on Chat GBT or one of those AI artificial intelligence sites, and it comes up and literally says HOAs in Florida cannot prohibit you from installing a metal roof. That's an example where the AI is absolutely wrong. Okay, so again, don't believe AI is gospel. Always talk to your own association legal counsel before believing what you read.
I've had people say, well, this is what AI says. I was like, well, that was absolutely true in 2018.
Right.
When the AI skimmed Richard's article that he wrote in 2018. It is funny how they gather this. It's usually from the news articles that we write.
Right.
Richard, a question on topic here. For roofs or hurricane shutters, does the board of director or the ARB have the responsibility to enforce particular colors or materials?
Well, that as a general statement, if you have certain guidelines that dictate colors and materials, yes, you need to enforce your rules, whether it's an ARB rule or any rule. Rules are made to be enforced. If you don't want to enforce the rule or the ARB restriction, you have two choices: change it to what you want it to be or remove it. But you cannot just have a rule on the books and say, well, we just don't care to do that anymore. If you don't like it, change it.
Does the type of roof discussion apply to window shutters also?
Yes. It says the board must adopt hurricane protection, which means any code compliant hurricane protection in the state of Florida, which would apply to windows, doors, garage doors, roofs, and whatever else hurricane protection there is.
What agency handles issues with HOAs following the statutes like the DBPR does for condominiums?
The division and the state only regulates HOAs in two areas: elections and recall disputes. There is no division of HOA to complain to. There is no, unlike the division of condominiums. So I always get a chuckle when the homeowner comes to the meeting at the HOA and says, well, I'm going to report you to the state. I'm always like, well, when you find out the person you reported to, you let me know, because I don't know who that division is. But in the area of election disputes or recalls in HOAs, the division does regulate HOAs, but otherwise it does not regulate HOAs. You basically have to go to court. The court system.
Your remedy is likely going to be offering pre-suit mediation to your association. And then if you can't come to an agreement whereby they'll start enforcing the covenants or doing whatever's at stake, then you'll have to go to court.
Right. So let's see, where are we? Items in the backyard, number 13. This is a addition to what John referred to earlier as the Homeowners Bill of Rights, which started in 2023, where the legislature started trying to cancel certain restrictions commonly found in HOA documents, like what you can put in the backyard. They essentially said in 2023 that if there's a prohibition on certain items in the backyard of your single family or your HOA parcel, if it cannot be seen from an adjoining parcel, from the front of the home, or from a common area, you can put whatever you want in the backyard. They've expanded that to include vegetable gardens and clotheslines, in addition to items that cannot be prohibited in the backyard if they cannot be seen from other lots or the front or the common area. Now,
Yeah, we still don't have an answer to the question I had immediately when they passed this last year or the year before. What about from the second story of the adjacent parcel? I mean, you're seeing it from the, or what if you're Kareem Abdul-Jabbar and you can just see over the fence? You're an unreasonably tall person. So these things I don't think have been litigated and are still open questions.
no, and we're going to get into this a little bit more in the next slide. Whether or not these substantive prohibitions that purport to cancel your pre-existing rules against what you can put in the backyard or what you can park in your driveway, whether or not those laws retroactively cancel your pre-existing rules that existed before the law changed, is a significant legal question that brings up the issue of what's called Kaufman language, which comes from a case called Kaufman versus Scheer. That's too complicated to really get into in this discussion, but don't believe ChatGPT or your neighbor that says, I read in the paper that they can't prohibit me from putting a shed in my backyard. That may be the case if your documents do contain Kaufman language, but it's very possible that your documents do not contain Kaufman language, and that law is not retroactive. So you need to go to your lawyer and ask, do these laws that prohibit certain restrictions about parking trucks and commercial vehicles and things in the backyard, do they apply to our HOA or not? And you can say that all turns on Kaufman language. And I don't say this to be flippant, but if your lawyer says, what's Kaufman language? You need a new lawyer, because Kaufman language is a seminal case in condo and HOA law, and any lawyer that practices in this area should know what that case is. And it's a complex analysis. So don't take it as gospel that you can't prohibit certain things in the backyard. It depends on the Kaufman language issue, which is also going to be relevant in the next slide.
It is very complicated, but people are going to be saying, well, give us the 30-second rundown. In essence, your declaration of condominium or of covenants for your HOA is a contract, and the government is not supposed to be able to interfere with your contract. But when you look at your declaration, it's going to refer to Chapter 718 or Chapter 720, and it may say as adopted at the time of this declaration, or it may say as adopted at the time of this declaration and as amended from time to time. If that from time to time language is in there, every amendment to 720 or 718 to the statutes is automatically incorporated into the contract. If it doesn't say that, then you and your lawyer have a fun discussion ahead of you.
Right. Number 14 from the previous slide, they've really tweaked the fining and suspension protocol for HOAs. Again, this is another example of condos and co-ops have the ability to fine and suspend use rights, just like HOAs. For years, the process, the timing, the protocol, the rules were all the same. Okay, it doesn't matter if you're a condo, HOA, or co-op. Board opposes the fine or suspension. You have a 14-day appeal hearing. The committee either approves or disapproves. Okay, that's basically still the process. But now for HOAs only, they've added to it. So again, it makes it complicated for something that is very common and similar to all types of community associations. Now the procedure is different for an HOA. So again, you always go back. Are you an HOA or a condo or a co-op? But for HOAs, the new law, and I'm not going to go through it in complete detail, you can read it, basically has a couple of things. First of all, if your board imposes a fine or suspension for a rule violation or for a failure to pay monetary amounts owed to the association, you have to have the fining committee suspension hearing, the appeal hearing, within 90 days, okay? The board imposes the fine. You have to have the 14-day mailed and posted notice committee hearing, the appeal hearing, at least within 90 days. That's number one. That's not too difficult. Clarifies that if the hearing is held by telephone or other electronic means, that's okay. You can have a Zoom finding committee or suspension committee hearing. It says that within 7 days of the committee's decision, you have to send a written notice of the decision to the owner, telling them what occurred, what was the decision of the fine or suspension committee. Here's the big one. If the board imposes a fine or suspension and then sets the date for the fining committee or suspension committee appeal hearing, which has to be 14 days away, if between that date and the date of the actual occurrence of the committee appeal hearing, the person corrects the violation, then there is no fine or suspension that can be imposed. So let me give you an example. And I've had this. Your documents say you can't leave your portable basketball hoop in the driveway when you're not using it. Okay. You can't leave it out overnight. Okay. So you have a rule that says you got to bring your portable basketball hoop into the garage, when you're not using it. So somebody leaves it out overnight. So the board imposes a $50 fine for violating the rule of leaving your basketball hoop out overnight. So then they set the hearing date 14 days away. And you, on the day before the hearing, you put your basketball hoop into the garage and you walk into the hearing and you say, here's a picture of my house. The basketball hoop has been removed and put into the garage. You cannot fine me or suspend me. Have a good day. Bye-bye. Okay. So if you correct the violation before the hearing, you cannot impose the fine or suspension. That kind of makes some sense because the fine or suspension is really a tool to get enforcement. Okay, so if you finally comply, okay. But I've already had this happen. I know John has had it happen. I'm sure you might have had it happen. We get people that like to play games. So what do? They leave the basketball goal out. The day before the hearing, they bring it in. The day after the hearing, they put it back out again. They get fined again. The day before the hearing, they bring it back in. And they go back and forth, back and forth, back and forth. The statute doesn't really address how you deal with that for someone who is just playing games by correcting the violation just minutes before the hearing. And so that's a problem. Number two, what about violations that really are not correctable? I mean, I ran over the stop sign or I broke the gate. I ran through the front gate and I broke the gate arm. Okay. You cannot unbreak the gate arm. So there are certain types of violations that if you impose a fine or suspension really are not correctable. You're going to have to talk to your legal counsel about whether this type of violation is a correctable violation or not a correctable violation. The final thing is, once you impose the fine and you send them that letter within 7 days saying the fine was imposed and the committee upheld the fine, you owe us $100, you have to give them 30 days to pay the fine, at least 30 days to pay the fine. Okay, number 15.
Before we move on, we have some finding questions, as you can anticipate. Can the board have violation fines that are immediate? For example, irrigation on the wrong date and or time. Can fines be posted on the owner for not following the rules?
That's a good question. That goes to the issue and a very common practice, particularly for large communities. Can the board adopt a schedule of what are called automatic fines that are adopted at a properly noticed board meeting and published on your website that says if you do X, it's $50, okay? Without having to have a special board meeting for John Smith who violated X. Normally, the board has to have a board meeting, 48-hour posted notice. The agenda says fine John Smith. They make a motion to fine John Smith for violating the rule, etc. Can you have a schedule of pre-imposed fines and avoid that initial board meeting? The law does not expressly prohibit it, but the law does not expressly allow it. But in my experience, it's fairly common practice, particularly for large communities, to adopt a pre-published schedule of fines so the board does not have to have a meeting every time. They look at the schedule, you left, you parked on the grass, it says no parking on the grass, or you turned on your irrigation on Tuesday when you're only allowed to do it on Wednesdays, automatic $25 fine. I believe that's legally enforceable if that schedule of fines have been imposed at a properly noticed board meeting and is pre-published in advance so people are aware of it. Then
there still would have to be a 14-day hearing note. so that
You
they
still would have to have the
Yeah.
hearing notice. So
That's
you,
why I think some people hear automatic fines and they forget that next step, the due process,
right,
to have a chance to say, no, this was a mistake. I did not turn on my irrigation, or
right. So
wind
you
is
would
stuck onto
still
my lot
have to
and
have the
I turned
hearing.
it
You
on.
still have to have the 14-day hearing
Right.
for that.
What does a board do if the community does not want a fining committee?
There's no fining committee. You can't fine or suspend because you must offer them the fining committee, not offer them. You must hold the fining committee or suspension committee appeal hearing with three persons, three owners that are not related to the board. If no one wants to serve on that committee, your owners have taken away one of your enforcement tools.
Right. You could still go to court to enforce your covenants, but you're not going to be able to use the fining capacity as one of those tools in your
Right.
arsenal.
Okay. Continuing on the fining and suspension committee rules, number 15, the legislature has now basically said if you are being fined for leaving your garbage receptacle at the curb or the end of the driveway beyond the time limit, let's say your documents say you must bring in your garbage can from the curb or out of your driveway no later than 6 p.m. on the day that it was picked up in the morning. Okay, that's a rule. You violate it. You now get a 24-hour grace period. They cannot fine or suspend you for violating that rule if you bring it in within 24 hours after the rule deadline. So you get a 24-hour grace period. The interesting thing is the law says leaving the garbage receptacle at the curb or the end of the driveway. That's literally what it says. Well, what if you say you got to bring your garbage can into the garage no later than 6 p.m. on the day that it was picked up? So you pull your garbage can back from the curb and you put it in the middle of your driveway. Okay? That's not the end of the driveway. That's not at the curb. Reading the law literally, they don't get a 24-hour grace period for that. Okay? You get a 24-hour grace period for leaving it at the end of the driveway or at the curb. If you pull it back and put it next to your garage, the 24-hour grace period under the statute doesn't apply. Now, I don't know if you're going to be that nitpicky, but again, the legislature writes these laws, and what our job as lawyers to do is, find loopholes, and that's a loophole. The second one is leaving holiday decorations or lights out beyond the period that if you say you must bring in your Christmas decorations no later than January 15th every year, you now get a 10 days? I think you get a
7.
you get a 7-day grace period. So if they're supposed to be in by the 15th, you have until January 22nd. Now, again, the statute says holiday decorations, and it does not define a holiday decoration. So traditionally, we're going to think of Hanukkah, Christmas, whatever, okay? But I bet if you sat down and looked at the calendar and applied every group of people and religious and societal holiday, you could probably find some type of holiday recognized by some legitimate organization virtually every day of the week. I mean, Arbor Day, I don't know, is that a holiday? So somebody that wanted to play games could probably say, well, I recognize every single holiday identified on a calendar, and so I can string my lights out for as long as I want. Again, don't know somebody's going to really.
Have you seen some associations adopt a schedule of official holidays?
I've seen them try, but then you start going down the rabbit hole of every type of religious and national organization, and where do you stop? I mean, I don't know.
What if they had a residual catch-all to any other good faith religious?
I don't know.
Yeah,
I mean, holiday lights are not the end of the world.
right.
Okay, number 16, voting fraud is a crime. Similar, they've enhanced the statute that was already there, similar to the Condo Act. You can't commit voting fraud or it's a crime. Now, number 17, which I'm going to scroll to, this is the big one that invokes the Kaufman language. And this is the one that people are really starting to push on. What it essentially says is, if your governing documents prohibit parking commercial vehicles or trucks in the driveway, this law says you cannot enforce that restriction. Okay, fine. I can park my commercial vehicle, Truly Nolan mouse car, in my driveway, despite the fact that it's a commercial vehicle and the governing documents say no commercial vehicles. But this all turns on the Kaufman language. If your document contains Kaufman language, very likely your ability to enforce the no pickup truck or no commercial vehicles in the driveway, that's probably not enforceable anymore. But if your documents do not contain Kaufman language, then there is a valid legal argument to say we are not prohibited from enforcing those rules. So again, it all turns on Kaufman language.
And
Item,
importantly for people to realize, the statute that it refers to that defines a commercial vehicle, it's 3 axles or more. So it's not just the stickers or a logo. It's a 3, it's basically a semi.
and it talks about your work vehicle. So, I mean, again, it's vague. I mean, I don't know. Is my Winnebago my work vehicle? I mean, these laws, again, the legislature listens to the homeowners that pounce on them with horror stories. I mean, it's very, very common to not have commercial vehicles parked in driveways and HOAs. That's very, very common, and there's a legitimate reason for it. And you chose to abide by those rules when you chose to purchase in that community. So now, you know, your next door neighbor is and I've had this literally. I don't live in an HOA community, but I've had a situation where the neighbor was a tow truck driver, and he would park his tow truck in the driveway next door, which I didn't really care about. But when he got the 4 a.m. or 3 a.m. call to go out to, you know, get a car, you know, that thing would fire up, and it was loud and it was noisy and it was kind of disturbing. So, I mean, again, the law
Those are
sounds
my
like
wife's
it's helping.
Mustang GT. So,
Yeah.
Richard, what about you get this a lot? There's always some confusion on this. Is there any comparable condominium right yet? I think is the
That's a
key.
great question. These homeowner bill of rights that prohibit enforcement of certain rules, particularly in the area of commercial vehicles and trucks, they do not apply to condos under 718 or co-ops under 719. So if your condo or co-op documents prohibit these kinds of things, that is still enforceable, regardless of whether your condo or co-op have Kaufman language. What it's going to be in the future, we don't know. The second bullet point here, this is what's kind of interesting. An HOA cannot you cannot prevent a property owner from inviting, hiring, or allowing entry to a contractor or worker that's going to work on the individual's personal home because they're not on the preferred contractor list. Okay. So you cannot, if you say we only allow this type of contractor to work on the roof, you cannot prohibit someone from hiring whoever they want to work on their roof of their single family home in an HOA. Additionally, it says you cannot require the contractor that is hired by the individual owner to work on their private property. You cannot require them to prove that they have an occupational license or to present or prove possession of of an occupational license. Which, you know, okay, if I want to hire this person to work on my detached single family home, they don't have a proper license to do the job. That's on me. I get it. Why does the HOA really care? But let's go back to the example of the villa or coach home HOA community, where that contractor, I only own a slice of the roof, and it's an attached roofing system that affects 8 other homeowners. Why should the HOA not be allowed to say you can't let somebody get on that roof that doesn't have a license when it's going to affect other, attached homes? That doesn't make any sense. Again, the legislature thinks that HOAs only cover detached single-family homes, which is absolutely not true. So this law makes some sense for single-family detached homes, but makes no sense for attached homes. So again, maybe they'll correct this in the future. I don't know. Number 19 makes it clear that when you charge interest on late fees or assessments or monetary amounts, it's not compounded. You cannot charge compounded interest. It's simple interest, annual interest, whatever you charge. Number 20, first responder vehicles. The term law enforcement vehicles has been now replaced with first responder vehicles. The law formally said that even if you prohibit certain types of vehicles in the driveway, you could not prohibit law enforcement vehicles. Now it's first responder vehicles. So if somebody, has a state issued first responder vehicle, you can't prohibit it from parking in the driveway. Next. We're getting close to the end of the HOA stuff, and then we'll wrap it up with a few other things. Number 21, this requirement has already come and gone, but as of on or before October 1st, 2024, the association in an HOA was required to provide a physical or digital copy of the association rules and covenants to every member or make them available by putting it on their website. You were supposed to do that by October 1, 2024. If you didn't do it, there's really no sanction, so you don't really have to worry about it. Number 22.
The part that I have people ask about is the portion that says if the rules or covenants are amended, you must provide an updated copy.
Well, yeah, that's troubling because effectively now when you change a rule or covenant, you have to put it on your website, which you're going to do anyway, and you're going to have to tell people that it's available. So it is just another piece of, busy work that you're going to have to do. And the real issue is there's
seems
not really
a little
much of
silly
a
if you amend
sanction.
the declaration, you've already sent it to all owners to vote on. And then
Exactly.
then when you record it, you're supposed to turn around and notify them again. But
Right.
but
MARTA
you can put it
revitals-
all on your website. Once
Yeah.
again, that's the way to do it. Just put it on your website.
MARTA revitalization, they've just changed the division in Florida that approves MARTA revitalization. I'm not going to go into what that is. If your HOA documents are older than 30 years or are approaching the 30-year anniversary of when they were recorded, you need to talk to your legal counsel about a potential MARTA impact. Again, if your legal counsel says, what is MARTA? You may want to look for new legal counsel because it is something that an experienced a community association lawyer should know what Markle Record Title Act is. Timeshares, I don't know if we have any timeshare people here. You can read this for yourself. I'm not going to go into detail, but if you're under Chapter 720, if you're a timeshare condominium, there was a change here regarding deleting facilities without the approval of members. The next one is mobile home subdivisions, Chapter 723. A Chapter 723 mobile home subdivision is a mobile home community where you own your mobile home, but you do not own the land that it sits on. You effectively rent that land. Not all mobile home subdivisions are that way. A lot of them, you own your land and you own your mobile home and you're effectively an HOA under 720. But if you rent the land that your mobile home is on, you're typically either a cooperative or you're a Chapter 723 mobile home subdivision. And there were some changes in the law regarding that, requiring mediation. If the park owner is going to raise your rates, you can require mediation under certain circumstances. There's also a part here for a live-in home healthcare aid number 2 here. If you're in a mobile home subdivision, there are some requirements about allowing a live-in healthcare aid. Can't prohibit it. Okay, now we're going to move into just some miscellaneous laws that apply to various things. John, do you want to take on some of these, or do you want me to keep going?
Sure. I'm busy trying to answer these questions, but are we to the CAMs and conflicts of interest?
Yeah.
Yeah.
Well, there's a couple of, I can run through it pretty quick. It's,
Okay. Go ahead.
Um,
I'll keep answering.
Okay, there's a number of laws that were changed affecting community association managers and community association management companies under Chapter 468. One of the big ones is, and I think this first one is good, and I think I know Wendy can attest to this because I've been through this with Wendy. When a management firm or manager gets let go and the new management firm gets hired, there has always been this, I didn't get all the records from the old manager. And the new manager says, I didn't get all the records. And the old manager says, I gave him all the records. And there's always this back and forth about cooperating with the new management company. Professional management companies like Precedent and the others, they don't really play that game. We all, as lawyers too, when we get terminated and have to deal with a new lawyer, we generally, as professionals, cooperate with the new lawyer, turn over the records to them and take care of it. But there are occasions where the management firm or the management company will not cooperate with the new management company. Well, now they've actually added some teeth to the law that says basically If a management company is terminated or a manager is terminated or the association asks for all their official records, the management company has to provide all the official records within 20 days, 20 business days. If they don't provide the records within 20 business days, there is now a penalty of up to $1,000 per day, up to $10,000 for failure to cooperate and turn over the records. So that actually is gives us some teeth against the uncooperative manager or management company that simply refuses to cooperate and turn over the records. So I think that's probably a good law. Number 2 is all about conflicts of interest with managers and management companies. And there previously, and now there are enhanced laws about the manager or management company disclosing any potential conflict of interest regarding other vendors. What effectively this means is if the management company has an affiliated division or company, like a gate company or a landscaping company or a pool company that may not have the same name as the management company, but it's affiliated with the management company in the sense that the same people own it or they work together, you basically have to disclose that you work with affiliated companies. And so when you promote this pool company or this landscaper, the management company has to say, by the way, we own that landscape company, or we have a financial connection with that landscape company. So, I mean, I think that's a good thing. There are some other requirements. Another one that is a little bit more difficult, I think it's number 4 in the item here. Even if a management company does not have an official connection to the vendor they're promoting, they don't own the landscape company, they don't own the pool company, so it's not a direct connection, but they receive a benefit from that company for referring business, they have to disclose that as well. That's a little bit more difficult. I mean, arguably, this means, even though the vendor may not directly work with the management company, if the vendor sends a Christmas gift basket to the management company or a case of wine or cookies and says, thank you for all the business you referred to me during the year, here's a token of my appreciation, arguably that has to be disclosed in the management company contract that vendors, even though we don't own that vendor, and we don't, directly control that vendor provides us things of value, potentially, you have to disclose that. So that's a little more problematic. And, certainly sending a box of apples is not going to really change anybody's mind, but, it's very common at the end of the year to give things to vendors to show that you appreciate their referral of business. But you
Richard,
got to
can
be
we
mindful of that
scroll
now.
through the page?
What's that?
Can we catch up on the screen with where you're at?
Yeah. I think that's number 4. And if the management company doesn't disclose these things, you can terminate the management contract, is what it effectively says. What I have seen most now is most management contracts will contain a paragraph about affiliated vendors that we may refer to you. The other one is there's a $2,000. Let me find that for you.
That's on number 2.
Number
2.
Okay, number 2. Yeah. If the association receives and considers a bid that exceeds $2,500 to provide goods or services other than the community management services themselves from the manager, the management company from their affiliated vendor, the management company has to provide a bid from a non-affiliated vendor. So if the management company is going to refer you to their affiliated pool company for a contract that exceeds $2,500, not only do they have to say, this is our affiliated pool company, the manager must also provide a non-affiliated vendor's bid as well. So that's an interesting new twist. Let's see. Whoops.
In the new statute, they've actually created a presumption of a rebuttable presumption that a conflict of interest exists if there's any contract that goes beyond CAM services.
Right.
And then you proceed to the analysis that Richard's been discussing. So they're really cracking down on this.
Okay. Number 4, for some reason, they said if you've been a community manager for more than like 12 years, you don't have to take the 10 hours of continuing education requirement for managers, which is kind of interesting. Number 5, as of January 1, 2025, the Division of Condominiums is going to make recommendations regarding additional official records condominium associations should maintain. So good news. We're going to get a list of more records we have to keep. Number 6, these are the miscellaneous laws. Number 6, I laughed about. It says the Florida Building Commission shall perform a study on standards to prevent water intrusion through the tracks of the sliding glass doors and prepare a report by December 1, 2024. I laughed at this because I could just imagine Governor DeSantis marks on his calendar, December 1, 2024, receipt of report about water intrusion under sliding glass doors. And when he didn't get that report, I bet he stopped the government and said, where the heck is that report? That's the most important report. It was required by law. Where is my report on water intrusion under sliding glass doors? Anyway, I don't think that happened, but I guess it makes some sense because water intrusion under sliding glass doors is often caused by wind-driven rain, or that's what the insurance company claims. And a lot of insurance companies disclaim damage caused by wind-driven rain, which in my mind is oxymoronic, because if you have a hurricane, of course, you're going to get water intrusion because the rain is being driven by 150-mile-an-hour winds. So conveniently, the insurance company said, well, that's wind-driven rain. It seeped in around the windows. The window wasn't blown in. It was driven through the cracks and crevices. So I guess trying to prevent wind-driven rain through the sliders is a good thing because you won't have as many claims, but that's kind of funny. Then finally, we're going to talk about a couple of what I'm going to call, and I hope there's no one here from the division on this inevitably, as condo lawyers and HOA lawyers, we follow the laws. And every year we prepare a legal update with the laws that pretty much directly impact you guys, okay? Inevitably, when we turn in our outline, and I think this is just bureaucrats needing to maintain their job, they will inevitably point to a few new laws and say, we need you to include these laws in your community legal update. And we read these laws and we say, what in the world does this have to do with condo, HOA, and co-ops and boards of directors? And that's what a couple of these laws are. So these are required because they told us we had to tell you about them, but some of them, frankly, make little sense. Number 7, this bill authorizes minors age 16 or 17 to work in residential construction if the minor meets certain criteria and is under the direct supervision of a person 21 years age or older with related experience. Effectively, I guess it's like you could have apprentices that aren't 18 that maybe work for the roof company, I suppose. I guess this could be related to condos and HOAs, but really, does that really matter to you? I don't know, but that's what the law says.
So you don't go calling OSHA if you see a young-looking person
I
in
guess.
school. I don't know.
Number 6, continuing education requirements. It authorizes the board or the Department of Business Professional Regulation, when there is no board that regulates the industry, to allow by rule that distance learning may be used to satisfy continuing education requirements for most professions regulated by the DBPR. Okay, I guess that's a good thing.
Vital for all of our boards to know that.
Right. Interstate licensure mobility. What this says to me, if you're licensed in one state for a particular item, then it makes it easier for you to port your license into Florida from your prior state based on certain criteria. Again, how is that directly related to your condo or HOA? I don't know, but that's what it is. So with that, that is our legal update. John, if you want to touch on some questions, or we have a little bit of time, we could kind of give a heads up to what's coming in HB 913, which is the new
Let's touch on a few of
condo
them,
bill.
and then I know a lot of people will want to know what's coming. Do SIRS, and actually this I think is addressed by the new statute. Do SIRS and non-SIRS have to be maintained in separate accounts, paid from each account, etc.? So you can't have SIRS and non-SIRS commingled, even if we treat them the same.
I believe you can commingle them in the same bank account for investment purposes, but you cannot commingle them using them literally.
Right.
And you
As
must
long as your
track them.
CPA is delineating
Yeah.
and it adds up in an audit.
But I don't think you have to open and pay for a separate bank account for CERS. I don't believe that's a requirement.
What else have I got? If election fraud occurred in a condo, is there an obligation, legal or moral, to inform the owners? Well, why don't we touch on what's the deadline to contest an election and who can contest an election?
Yeah, you have 60 days to contest an election through the division. And my understanding, which I find kind of odd, it can only be contested or challenged by a candidate, not just an actual voter. Now, the election fraud laws are not through the division, really. They're really through criminal state attorneys. So I don't believe you would be limited to bringing a allegation of criminal election fraud through the state attorney by the 60-day deadline or the fact that you're not a candidate. I think that's a different
You're going to have admissible evidence that a
yeah.
prosecutor would be able to say it turned the elect. Anyway, that is a good point. Actual fraud is a criminal matter, so it's a little different than what the division would be doing. Before turnover, do developers still have to follow HOA requirements such as meeting notices when the board members are employees of the developer? I.e., does the developer essentially have license to do things that may conflict with 720?
There is no exception to following the proper meeting protocols and all of that you have to follow post-turnover. The developer has to follow pre-turnover effectively. In reality, they don't do it. And that's just the reality. They don't hold a board meeting to vote to sign a contract. They simply sign the contract. That's very common. But legally, they're supposed to follow the same rules.
Okay, with our 7 minutes, I know there are a few topics that most people are going to be interested in. And again, what we're going to talk about, other than what may deal with managers and CAMs, is going to be condominiums. And the big one, Richard, that I hear is, what is this about? If we have a board meeting on Zoom, we have to record it and make it an official record.
Yeah, the new HB 913 imposes all kinds of new requirements for board meetings for condos only. And one of them is if the board has the board meeting via Zoom or the annual meeting or members meeting via Zoom, it must be recorded and it must be retained as an official record. Oddly, it does not require the same thing if it's the traditional speakerphone only board meeting. It doesn't require that. And this kind of goes counter to what our legal advice has always been to boards is
well, I'm not sure about that. I went and reread it. I think in another part, it does talk about,
okay.
I think it does. That was my first impression, but then rereading it in totality, I think it does.
Okay.
I thought we had found a loophole, but I don't think so.
Yeah. Well, the bottom line is we always advise against recording a board meeting because it keeps every word said verbatim. And then that becomes a gold mine for lawyers and insurance companies to go back and scrutinize the minutes and try to use what was said against you. So we always advise don't record the meeting and only take down, motion, second, vote, call to order, and the things that you have to have. Don't load your meeting minutes up with verbatim recitation of every word said because it's more often used against you. Unfortunately, that's going to be much more difficult now because this new law that says if you hold the meeting via Zoom, you've got to record it. Another interesting twist in the law, and again, we're giving you our kind of 2-minute review of that law. We haven't really sat down and dissected it, which we will issue another legal update like this one with the more
Once the governor signs it.
definitive. But one of the other weird ones for condos is, and I might be misinterpreting this, but it appears to me to say, if you hold your condominium only, not condo or not HOA or co-op, but if you hold your condominium members meeting via Zoom, then a quorum of the board of directors must physically attend the annual meeting at the actual physical location, not on Zoom. That's what it says. And I find that, first of all, why does a quorum of the board have anything to do with a members
The
meeting?
members meeting,
It's a
exactly.
members meeting. And why must the directors, which are also members, forced to go to the physical location of the members meeting when all the other members can appear via Zoom? The only thing I can think of is the legislature, this is my guess. They don't want that. They probably had people complaining that, look, the board holds the annual meeting and they never even show up. So we cannot, physically, accost them and yell at them and hold them accountable. They're always on Zoom and they hide behind the Zoom. So I'm guessing they said, well, you got to show up at the meeting. And so you can be, held accountable and called to task. I don't know why it's there, but it's a really silly law if I'm interpreting it correctly.
Obviously, another big one's going to be the extensions given for milestone and SERS reports, which should have been done. And we kept yelling at everyone to get it done by the end of 2024. And now I guess we'll keep yelling at you to get it done by the end of 2025.
Right. They have done one good thing. The 4-unit exception in a 3-story or less condominium with four units or less was exempt from the milestone study, but for the SERS, the law currently says it's 3 units or less. So if you were exempt from the milestone study because you're 4 units and only 3 stories, you still had to do the SERS because the exemption was only 3 units. They've now changed the SERS exemption to match the milestone. And if you're 3 stories, but you only have 4 units or less in that building, you don't have to do SERS or milestone. That is a good law to make at least the laws consistent.
They've also raised the threshold from you had your SERS components, which were delineated, but then it was anything over $10,000. They've raised that to $25,000, which is helpful. And they've given some more flexibility about how you can pay for these items, which we don't have time to get into that. It's a little complicated to explain, but stay tuned. You do have some new flexibility and some new options there. One thing that all board members are going to have to sign an affidavit when they get the SERS. So they're tightening the screws on the board members to you knew you had this, you knew you had to follow it. So I think that makes sense to me.
Sure. So that's it
First-
for 2024.
When we first got on, didn't you mention something like for SERS that they could have a line of credit
Yes.
if they didn't have the funds?
Yeah.
You can have a line of credit established. There are other, as John mentioned, there are other funding vehicles that you can put in place that won't actually require you to collect the money year after year after year and just stick it in a bank account, which I think is a very good idea. So I don't know if we lost John, but
No, I'm still here. I was just seeing
Okay.
if there's any other hot button issues into 2025, but I think that it's noon. We promised to have people done. I appreciate everyone taking your time to sit and listen to us drone on about association law, and appreciate Wendy and President. Do you wanna close us out, Wendy?
Sure. So a lot of people have asked about the PowerPoint, the document. Sarah at Richard's firm will have it. We'll make sure you get it. Same thing with the recording. It'll probably be available for you to view on both their website and ours. But I'll find out from Sarah and we'll certainly let you know. If you learned one thing today, it was worth our time and the cost of admission. So thank you for joining us. I know I learned something today. So as always, it's a pleasure working with you, Richard. Thank you.
yeah, thank you, Wendy. Bye-bye, guys.
Thank you, everybody.